Morning, good morning. Happy Tuesday. It's the Ethics Committee of the State Senate, and it's about 8:33 or so, which is pretty good. We've got a note the presence of quorum. We have some other members who will be joining us momentarily, but in the essence of time, we'll go ahead and begin the meeting. I'm going to ask Senator Robertson, would you mind opening us in prayer this morning?
If you're comfortable, bow your head with me, please. Heavenly Father, we come before you, Lord God, as your humble servants, asking, Lord God, that you give us the wisdom and the discernment that we need today, Lord God, as we make these decisions. Let us not forget those around this capital in need, Lord God, those living on the sidewalks, living on the streets here in the city of Atlanta, Lord God. Those not only in need of your warmth and your compassion, Lord God, but of food and love and caring. We ask these things, Lord God, in your precious name. Amen.
Thank you, Chairman. Ladies and gentlemen, we have only one bill on our agenda this morning. So we have House Bill 976. This is a substitute. It's a Senate substitute to House Bill 976. Chairman LaHood is here. And I'm going to join Chairman LaHood. Chairman LaHood, if you'll come and join us at the desk. I'm going to join Chairman LaHood and present the bill. And then I'll ask Senator Williams to assume the chair while we're presenting the bill. We'll take questions from the committee. And then I'll reassume the chair and we'll take questions and input from the public. And then we'll have conversations on how the committee chooses to move forward. So, Chairman Williams, if you will. Assume the chair and we'll present HB 976.
All right, go right ahead. Your mic's alive. Thank you.
Thank you, Mr. Chairman and committee. Thank you very much. I want to thank Chairman LaHood. We've been working diligently together to craft some election legislation that will be beneficial to Georgians and help us to ensure that our elections are conducted appropriately and that individuals have confidence in these elections. I want to remind the committee and the public that 4 years ago when I assumed responsibility for this committee, I had only three objectives. Number one, every legal vote counts, period. Every legal vote counts. Second, every county follows Georgia law. Radical thought. Every county follows Georgia law. And then finally, I have confidence that my vote counts and you have confidence that your vote counts. That's what we're trying to achieve. That's our objective. So I want to present to you the Senate substitute to House Bill 976. I'm working off of LC 473074S. Is that correct? That's correct. Thank you very much. All right, we're going to go through this section by section. And after I've gone through the bill, I'm certainly happy to entertain questions from the committee. And we'll resolve any concerns that you may have there and then have conversation. You need a copy?
I have the wrong LC. Thank
okay,
you.
Very good.
Appreciate it.
Look at the one you had just out of curiosity. Yeah. There you go. All right. I'm in section 1. Section 1 deals with the clarification of residency so that when a registrar registers an individual as a voter in Georgia, they must be eligible to vote based on their residency. And this is Code Section 21.2.217. I point you to, first of all, to paragraph 1.1, which is on line 20. This deals with the homeless challenge that we have in our state. We want to protect the rights of our homeless to participate in the election process. But unfortunately, they don't have an address, a physical address that we can communicate via mail with them. So Section 1.1 provides for the fact that if the residence of any person in the state who is homeless and without a permanent address, their address, shall be deemed the location of the courthouse in the county in which they reside. Now, I would clarify the fact that that's their mailing address. their precinct can be assigned by the local election board as the precinct nearest to where they normally would be present. So that's the first question, that's the first change. On line 28, we begin to clarify what constitutes residency. So, if a person, this is on line 28, if a person has registered to vote in another state, county, or municipality.
Hold on just a second, Mr. Chairman, I have a question on,
Chairman Burns.
Sure.
On line 20, that portion you read, you said the courthouse would be their
Would be their mailing
permanent
address.
address.
Permanent address.
But their precinct would be determined by where they normally,
That is
Or-
at the discretion of the registrar.
okay. And I know in some areas here in Georgia, we determine residency of those unsheltered and homeless by GPS as far as the nearest corner, and in some cases, seriously, the nearest tree, some of these other things.
Right.
So we would have to come up with some way to determine so that if the individual lived in one part of town during the summer, lived in another part of town during the winter, we'd have to determine the registrar's office would have to determine what would be the most consistent place.
The local election board would have the responsibility of determining the assignment of a precinct for a homeless individual.
Okay.
Now, they would only receive the mail communication from the Secretary of State or the local election board via the courthouse. They would go to the courthouse and retrieve any communication in that point. But they would be assigned the nearest precinct based upon the local election board's decision.
Okay. Okay.
And that's currently that's currently the case. I would say that right now, an attempt to mail to that location would be inappropriate.
That's right.
Because there's no ability to receive mail at an intersection of a road or a GPS location.
And do you think the courthouse would be better than the registrar's office?
the post
They
office.
can certainly use, they're generally co-located, they could use the registrar's office if they chose.
Yeah, in Columbus, they're in two separate
different
parts of
locations.
town. You have the Citizen Service Center down on Macon Road, then you have the courthouse, which is downtown. So just as we move through, just as far as the thought process.
As I say, we may choose to identify the registrar's or the local board of elections office as the location. I would point out that we have other utilizations of the courthouse as the location of residency to protect individuals who have maybe been abused and need to have their physical location protected.
Yes, sir. Thank you, Mr. Chairman.
I have another question for you.
Sure.
Yes, sir.
Thank you, Mr. Chairman. I agree with the majority whip. I think we need to specify also if you're going to use courthouse, where in the courthouse. In the Eastern Judicial Circuit, you have probate court, superior court, recorder's
Happy
court,
to-
magistrate court.
Happy to consider that as an amendment as we move forward. But I think the most important thing is we're trying to provide a mailing address for individuals who may not have a permanent address.
In the past, we used the post office. We didn't use the courthouse, we used the post office.
I would suggest that the post office is a federal building,
Right.
and this is a local election issue. So, and that person would not have a post office box per se. It would
No,
be general
but-
delivery.
But the post office in our town, the post office actually held mail for those people.
I would hope that we could accommodate our homeless voters by identifying an appropriate place for them to receive the mail.
Go ahead.
That's our objective.
One suggestion there, just to piggyback off my colleagues, is instead of specifying courthouse to more broadly say a building, government building as determined by the local registrar, something that gives
As I
local
said, when we
flexibility.
get to the amendment phase, hold your thoughts, please, and hold your suggestions. When we get to the amendment phase, we'll consider your recommendations.
Okay. All right, great.
It's going to be a
Thank you.
long morning if we debate each issue
Yeah, go right
at
ahead.
this point. We're trying to get just an understanding of what's in the bill. All right, in lines 28 and following, This clarifies, is an attempt to clarify how a person who has relocated shall have lost their residency in Georgia. And by losing their residency, they would lose their voting privileges. So if you notice on line 28, if a person registers to vote in another state, county, municipality, or legislative district of any type or sort, that person shall be deemed to have changed his or her residency. I would think that if you register somewhere else, you have intended to change your permanent residency. And then in 31, if that person subsequently return to Georgia. So if a person registers to vote in another state, county, municipality, or legislative district of any type, and that person shall be deemed to have changed his address for residency purposes, in section B, if they return to their original address or a new residency after voting or registering to vote in a different state, such person shall update their registration with their current residency jurisdiction in order to be deemed a valid elector and resident of such jurisdiction. So I can go to another state, register to vote in another state. If I return to Georgia, I need to update my residency. I need to clarify that. Now, the likelihood is that individual is still on the Georgia voting rolls in a inactive status. They have not voted in Georgia. They have voted perhaps in another jurisdiction. But if they return to Georgia, they must update their voter registration to show where their current residency is. It could have been at the original residency location, or it could be at a new residency location. And then finally, section C, subsection C, clarifies the fact that a post office box is not a residence. It's not sufficient to establish a person's residence. Going back to A, we might consider if a person votes or registers to vote. You'll see that language a little later on as well. But section 1 deals with residency. There are no other changes in this until till page 4. Highlighted lines 83 through 94. And basically this lists out what a registrar may consider in determining a voter's qualifications to register and vote. Registrars to whom such application is made shall consider, in addition to the applicant's expressed intent, any relevant circumstances determining the applicant's residence. This is already in code. The registrar taking the registration may, notice the word may consider, that's currently in code, and then it lists a series of things that the registrar may consider. The only thing we've done is added the National Change of Address program so that the registrar may consider information from the USPS. But that is not the only thing they would consider. Section 2. Section 2 deals with the ability to appeal a decision of the Board of Registrars. And currently, if you'll note on line 106 and following, this is current statute. Either party shall have the right to appeal from the decision of the registrars to the Superior Court by filing a petition to the clerk within 10 days. There's been a recommendation that there be a two-step appeal process so that the first appeal of a registrar's decision, again, the objective here is to get every county following Georgia law. The first level of appeal is to the state election board, and then if that is unsatisfactory to the challenger, then it would appeal to the superior courts. So section 2 deals with the appeal of the registrar in determining whether or not an individual is an eligible voter in Georgia. Section 3. Section 3 deals with the same issue, except it deals with the issue of a challenge to an elector. So in this case, if there's an elector challenge on lines 18, 19, and 20. If there's an elector challenge and the registrar denies the challenge, the challenger may appeal the denial to the first to the state election board, and then to the Superior Court as appropriate. I would point out on line 16. This is current law. Upon the filing of such challenge, the Board of Registrars shall immediately consider such challenge and determine whether probable cause exists to sustain the challenge. I think I would like to ask the committee's clarification of the word immediately. What does that mean? Is that within a certain period of time? I'd ask the committee to consider that as we get into further discussions about modifications to the proposed legislation. The most significant part of Section 3 deals with probable cause, beginning in lines 123 and following. What is probable cause? What would be sufficient cause to sustain an elector challenge? This is an elector challenge, someone who has voted. What is probable cause to sustain that challenge, and then conversely, what is not sufficient? So probable cause shall include, but not be limited to, an elector who is deceased. Seems rather obvious. If the person is deceased, they should not have voted. An elector who is voting in voting or registering to vote in a different jurisdiction. So, if I'm registered in Alabama and I voted in Alabama, then that would be sufficient cause to sustain a challenge to an elector. An elector obtaining a homestead exemption in a different jurisdiction. And this relates to residency. So if I have a homestead exemption in North Carolina, that would mean that's my permanent address, and I would lose residency and not be eligible to vote if I have a homestead exemption. And then finally on line 126, an elector being registered at a non-residential address. And this begs the question of a location that is not a location of domicile. If that person is homeless, then we have given them the option of having their mailing address as a courthouse or whatever area the committee chooses to identify. But I'm thinking in terms of a non-residential address, an open field, a location that is obviously not a residency. It could be a manufacturing plant. It could be a non-residential address. So that's the objective there. If a challenged elector's name appears on the National Change of Address database as maintained by the U.S. Postal Service, and having changed such elector's residency to a different jurisdiction. So if your name pops up on NCOA, the presence of such elector's name on such a database shall be insufficient to cause to sustain the challenge against the elector unless additional evidence would indicate that that elector has lost his or her residency as determined by 21-2-217. And then there are a few exceptions to challenges. Any challenge of an elector within 45 days of a primary, runoff election, or runoff election shall be postponed until after the certification. So you would not challenge any voter within 45 days of an election. Any challenge to an elector who is determined to have residency.
You can literally ask it to do anything.
You can literally ask it to do anything. Ask it what we do about immediate, okay? Ask Siri immediate, okay?
I'm looking at election board material.
We're doing a little background research here. Siri's
I
helping.
have a question that will be coming about election boards, I promise.
Okay. Back to line 136. Any challenge of an elector is determined eligible based upon 8, 10, or 11. If you jump back just a few pages, you'll see 8, 10, and 11 in section 1. 8 deals with someone who is a student. 10 deals with someone who's in the armed services. and 11 deals with someone who is in the District of Columbia in government service. So basically, we protect those individuals. And then finally, any challenger of an elector that occurs during a primary or general election shall continue through the runoff or the runoff of the primary or the runoff of the general. So, Section 3 largely deals with codifying and clarifying what would constitute a sustainable challenge to an elector. Section 4. Section 4 is a very long section that makes limited changes but significant changes to chain of custody. I would point to the committee to the fact that this was a portion, actually Section 4 of House Bill 17. This was Chairman Alan Powell's section on chain of custody, and it's been adjusted and modified. This particular section has gone through the House multiple times, but has not been acted on as a whole, as a House Bill 17. So this is one section out of House Bill 17 dealing with chain of custody. And this language, you'll notice on line 52, there's a small change. Unauthorized access to and shall document authorized access to, The Board of Registrars I'm beginning in 150. The Board of Registrars or absentee ballot clerks shall keep safely unopened and stored in a manner that will prevent tampering and unauthorized access to, and shall document authorized access to. So we're trying to protect and document access. At the bottom of the page, all accepted absentee ballots shall be securely stored in either a sealed container or appropriately secure in an access control room that will prevent tampering and unauthorized access prior to scanning of the ballots. You flip over to line 219. With the documentation provided by subparagraph A, little a1, capital A of this code section for storage in a manner that will prevent tampering. If I flip over to page 10, lines 248, the sealed containers containing certified and accepted absentee ballots are unsealed and verified for integrity while the absentee ballot envelopes are opened and while the absentee ballots are scanned. So in every case, in Chairman Powell's work toward chain of custody, he is protecting the integrity of the ballot. He has worked with the Secretary of State's office on this language. He's modified it, and I believe that that they are comfortable with his modifications. I'll continue on line 12, 298, lines 298 through 302. At the conclusion of scanning of ballots, such scanned ballots shall be stored in tamper-resistant containers sealed with numbered seals, the number of which shall be recorded as a chain of custody document specified by the Secretary of State, and such forms shall be signed by the person storing the ballots, and the date and time of the storage shall be entered on such forms. Moving over to page 14, again, trying to secure ballots, absentee ballots. Line 347, such boxes or bags shall be sealed and witnessed, verified by each person taking custody of such items by each person's signature and date and time taking custody. Again, it's a chain of custody document. Line 357, in secure sealed containers with chain of custody documents as specified by the Secretary of State with the signature and the date of the time the person is taking custody. We're getting close to the end, 365. With an accompanying chain of custody document. So if you're gonna utilize ballots or access ballots, there has to be a chain of custody document. And the lockbox of the ballot box shall be securely sealed if it is not in the direct control of a poll officer, or if it's transferred from a different room to our facility for tabulation. And finally, in 390. There shall be a chain of custody document as specified by the Secretary of State on which is recorded and witnessed the same, the name and the signature of such person taking custody. So, as we look at Section 4, recall that this section came from House Bill 17. It was fully vetted in House Government Affairs. Is that true, Mr. Chairman?
That is correct. We passed it out, I believe, 3 times now.
I believe this bill has been vetted at least 3 times in the House Government Affairs Committee, and it was passed out of that committee 3 times. And it got held up in rules or stuck in rules and was never, had the opportunity for a floor vote in the House. However, this language makes common sense. It strengthens the integrity of the election process by maintaining close chain of custody requirements for all ballots. Finally, Section 5. Section 5 is Chairman Blackman, Shaw Blackman's language from House Bill 426. And I'm going to invite Chairman Blackman, since he's here, if you don't mind. We have an amendment, but I'd ask Chairman Blackman if he would first go over what Section 5 is, and then I'll ask you to speak to your request to adjust this language for the committee.
Thank you, Mr. Chairman, members of the committee.
Oh, we're on 16.
Let me get over to this page here so that I can get to it. All right, just in case. I'll try to do this briefly, but 426 was actually been worked on for about 3 different sessions, and it dealt with ballots and election materials as open records. So, we have gone through and taken a lot of input from various stakeholders, and then with the images that are being made available through other bills that have passed through, this is sort of a hybrid version of that. And I think the run-of-the-mill or kind of your garden variety opportunity at these ballots is essentially if you have the original images that were scanned in, and you see something that looks like, well, maybe these were scanned twice, maybe there's some sort of error, then I can access the ballots through a higher resolution image, and I can witness the person scanning these ballots. The elections officials that are responsible for doing this would not allow anybody to touch the ballots, but they are their custodian, and they could charge a reasonable price for doing so. And again, it's really all about transparency. I think if you look at some of the practices that we've seen elsewhere, if we're asked to go to other countries and validate elections or look at what they're doing, if you were to say the government's going to say, well, here's the results, we're going to count the ballots, we're going to give you the results, and then we're going to go hide the ballots, I think we would not be interested in validating those results. So this is just one extra step in transparency, and benefits I think all the citizens of Georgia.
Would you like to speak to your amendment?
The amendment just I
Is
think
the amendment in your folders, just for clarification? Thank you. This is Amendment 470092.
I think the amendment essentially would allow access to the ballots. I think as written in Section 5, that it provides for those scans and the witnessing and thereof and the charging of a reasonable price. I think access to the ballots is necessary, so it brings in some additional language that would allow that superintendent or election official access to those sealed ballots in order to make those scans.
I have a question. Yes, sir.
Maybe Chairman Burns can elaborate, but it looks like the amendment clarifies that the custodian of the ballot is actually the clerk of court, not the registrar's office. Is that right?
That's when the ballots are sealed after certification.
Right.
They are held technically by the clerk.
Right.
Not always physically, but technically.
But
and
Section 5 currently doesn't specify the clerk of court, but the amendment does, I believe.
Yes, sir.
Yes.
Okay. Thank you.
What we would propose, I believe, with Chairman Blackman's concurrence, is we would replace Section 5 of the LC with the amended language. Is that correct?
Yes, sir, Mr. Chairman.
All right, that's the essence of the bill. The only other area of discussion really deals with the effective date. I'd like for the committee to consider the effective date. I think most sections of the code could be implemented upon the signature of the governor when it becomes law. However, Section 4 requires a bit more procedural changes from the Secretary of State's office, so I would suggest that is a deferral to January 1st of '25. With that, Mr. Chairman, I'm happy to take questions from the committee on House Bill 976 and then try to address your concerns.
Yes, sir.
Thank you, Mr. Chair. Currently, do we know how long it would take? I'm going to go into Section 2, I'm sorry, which is dealing with the State Election Board, line 99. On the appeal from the registrar's decision to the State Election Board, how many times does the State Election Board actually meet?
They only meet once a quarter, and that creates an issue, sir.
Okay.
And we recognize that. I'll be candid in order to defer further discussion here. In discussions with the State Election Board, the Secretary of State, and the Governor, I will request that Section 2 be removed.
Okay.
Although I think it's a good idea,
Yes.
I don't think we're quite ready to request the State Election Board pursue that. Now, I would ask your indulgence in Section 3 on the word immediately in line 116.
Right, how to define
How
that,
do you
and that's
define
not defined even now,
I
correct?
know. How is it
Right.
defined now? I don't
Yes. Well, that was my questions. So see, I actually was a researcher, Mr. Chair.
Okay.
What I have witnessed as my experience as a registrar was someone would challenge an elector when they were going to vote. And then that person, there was a challenge hearing held immediately right then,
As in,
right then,
right then.
right then. While the elector was there, members of the elections board, registrar's office,
So it is indeed immediate.
It
is
is
not
in-
delayed in any way.
and I'll revert back to the Secretary of State's office, but that has been the practice
Okay.
when people were voting in person.
So immediately is an appropriate word.
Yeah, it is an appropriate word.
Thank you.
Let's see. Pass.
Yeah, I want to go back to Section 1, dealing with the homeless
Yes.
situation. That was an interesting conversation we started out having earlier. So I'm just trying to think how complicated that might be to list a homeless person's mailing address as the courthouse. Depending on what size county you're in, that could be a huge facility like Fulton County versus.
Exactly. In Fulton County, I mean, we're looking at
Yeah.
a number of issues.
Would it work better to, dealing strictly with elections issues, would it work better to have that address to the registrar's office?
Happy to consider that.
Is that, do you see any issues with that? Because it's, what's the likelihood they're gonna have mail anywhere else? I mean, and most likely the post office either will send it back as, return the sender if it's junk mail, or if it does make it to the courthouse, most people in the courthouse are never gonna have heard of this person before, and they're gonna end up throwing it in the mail. It's gonna go to the trash.
Right.
But if it goes to the registrar's
Happy
office,
to consider that as a friendly
I
amendment.
think that's more appropriate for election-related materials,
Clarify.
nothing else, so.
And just to make a point of, back years ago, the homeless has not just happened. This has been going on for a long, long time.
Right.
And people would actually give, when they registered to vote, they would actually tell which bridge they lived under. And they were actually issued a ballot style for that precinct. And they would go to the post office, and this is something we could ask someone with the postal, but they would call for their mail at the post office. These people would.
Chairman, I hate to say it, but I can't even get my mail at the post office right now. I don't know how a homeless
I
person's
can't
going to
either.
get theirs.
Well,
This was
We have
prior
a
to
real problem
COVID,
in
and
this
prior
country.
to this issues that we're facing now. But I agree with you.
But
I think the post office may have bigger problems than we have here
That's right.
in Georgia.
Yeah.
But I concur with the leader that a clarification to say the registrar's office or however the committee chooses.
Yeah.
We'll consider that as a.
Seems practical to me. I don't know if somebody else
We'll consider
has
that as a friendly amendment
Yeah.
when we get to that point. That's
Thank
okay,
you.
Mr. Leader.
Thank you. Let's see,
Other
number
questions?
4.
Thank you, Mr. Chairman. I have concerns, Section 3, right around Section 125, dealing with the probable cause to challenge voters, especially at a non-residential address.
Right.
And immediately, I went back to several of my relatives that would have had a homestead exemption, but they would have been in a nursing home, and that is a non-residential address. But they still have the right to vote. So,
I believe a nursing home is indeed an appropriate address, is it not?
Well, that could be a temporary residence too in a nursing home, because a lot of nursing homes are rehabilitation centers.
Centers.
So they're not permanent resident there. They could still vote using their residence where they claimed homestead exemption.
Would that homestead exemption be in another state?
no, it wouldn't be. But if you say jurisdiction, if you pull up your Secretary of State voter registration, it'll tell you that this is the jurisdiction. It gives you the subsets of all the other smaller jurisdictions that you would vote in by precinct.
Right.
And so to be able to challenge an elector based off of any one of those changes, if they have a homestead exemption and they change their residence because they're in a nursing home, but they still own this home, they haven't sold it. I just have great concerns about that because, as you all know, I took care of my grandmother who was passed away at 92, and she did own her home until the day that she died. She just couldn't stay at her home, but we did everything for her by taking her where she needed to go. And I would have an issue with somebody challenging my grandmother's right to vote based off of some of those criteria.
Thank you for your concern.
Number 5.
Thank you, Mr. Chairman. To piggyback off of my colleague, Senator Mallow, a concern around the national change of address program. There are many reasons why folks use that program to change their address, even though they don't change their residency, whether it's a small business owner, whether it's an elected official trying to avoid threats, whether it's someone who is trying to make sure the mail gets to a place where they can easily access it, because frankly nowadays most of us don't check our mail frequently. There are many reasons, safety reasons, mail gets stolen. So there's all kinds of reasons that people use that program, and I'm concerned that what we are seeing now, which are mass voter challenges, this program will now be used to justify and fuel those mass voter challenges even more, when the vast majority of those people, including myself, would have legitimate reason for wanting to change our mailing address.
I would ask to direct the senator's attention to line 129, the last word. What is the last word on line 129? The last
Yes.
word on line, it is, and so the fact that my name appears on a national change of address registry, that is insufficient cause to sustain the challenge unless they have been deemed to have lost their residency per 21-2-217. So all that does is it is another option for the Board of Elections to consider when presented with a challenge. So if I challenge the registration of a individual based upon NCOA, that in and of itself is not sufficient. It must also be supported by one or more of the defined elements in Section 2-217, 212, 21-2-230, lines 23 through 32.
But Mr. Chairman, if I may, the concern here is that what these sections do not address is the fact that we've seen a massive influx of mass voter challenges, the overwhelming majority of which are unsuccessful. And what this would do is further allow folks to, usually one or two people, to challenge tens of thousands of electors. And even though it says that it would be insufficient, you're still going through resources at the county level of having to process all of these insufficient challenges, which ultimately, at the end of the day, cost taxpayers in those local counties money, because obviously the state doesn't provide any resources for those challenges.
I hear the senator's concern. I would suggest to you that this clarifies what would be a sustainable challenge. And if I look back on 23 and 24, 123, 124, 125, a sustainable challenge is an elector who is deceased, an elector who is voting or registering to vote in a different jurisdiction, an elector obtaining a homestead exemption in a different jurisdiction because that indicates a change of permanent residency, or an elector being registered at a non-residential address, a field. So, this clarifies the challenge itself by codifying the fact that just the mere presence of some name on an NCOA is not sufficient to sustain a challenge. It must be supported by some additional evidence. So I would hope that indeed this would reduce the number of challenges because they would realize that they cannot rely exclusively on an NCOA. They must have additional evidence. So the objective here is to clarify that NCOA is not in and of itself a sustainable reason to deny or to uphold or sustain a challenge.
Thank you. And one more quick question. Going back to section 1.
Yep.
What's the need, what's the intent behind that 1.1 around the homeless?
To make sure that the homeless are not excluded from the voting process. It's to ensure that they are included, and included in a way that is meaningful so that they can receive communication from their local election officials or from the Secretary of State at a location where their mail is protected. It's not sent to a third party to disseminate as they choose.
Senator Robertson.
Yes, sir. And Chairman, you may have just answered the question for me. I was pondering the question from the other end about the nursing home and other things. Yeah, I mean, there's a great chance my wife will have the opportunity one day to place me in one of those institutions.
It'd be a sad day, Mr. Chairman.
Yes, sir. But my homestead,
First.
but my homestead exemption would remain in Harris County, where I live. Therefore, if I were voting at in a facility, I would still be voting the same ballot that is attached to my permanent resident. Is that not?
That is correct.
Is that not true?
Regardless of where you may be placed or supported, your permanent residency would remain at your location.
Absolutely. So I wouldn't be. I'd be receiving the exact same ballot that my wife would be voting there at home. I would be receiving in wherever I might be.
That's true.
Okay,
That's
thank
true.
you.
And I think that would address Senator Mallow's concern in the fact that his mother maintained her permanent residency at the place of her homestead exemption. She might be living in an assisted living facility, but she would vote the ballot of her home jurisdiction.
That is correct.
Senator,
Such as a college student
A
or
college
military
student
officer.
or
Same
someone in
thing.
the military, someone assigned to a military installation somewhere in the country would receive their home ballot.
Senator Hassett.
So I've got a quick question about line 126,
Okay?
where it says that probable cause shall include, and then it, an elector being registered at a non-residential address.
Yes.
And then when you flip back over to section 1, line 20, if you're a homeless person, the residence of any person in the state who is homeless shall be deemed the location of the courthouse. Does that open it up to where if a homeless person votes in an election, that's probable cause to challenge the election?
Say that again, please, Senator.
So if a probable cause shall include an elector being registered at a non-residential address, and then the residence of a homeless person is the courthouse.
Or the registrars. I'll be happy to entertain clarification language to ensure that someone who is homeless and registered at the courthouse, that non-residential address would not be applicable.
Okay, thank you.
I have questions on that non-residential address. I grew up in a funeral home,
Okay.
and I lived in that funeral home, and I have an apartment in my funeral home.
Did that apartment have a separate address, or
No.
was it the same address?
Same address.
Same address?
Same address. Also, you have some people who own a store, and they may live in the back of their store.
Absolutely. We have that.
And use that commercial address, so there's a issue there.
I'm happy for clarification.
Yes, sir.
Mr. Chairman, isn't it true, though, that address would be the address that you would register when you go to register to vote?
Exactly.
You would register the apartment at the funeral home, God bless you, or you
Hopefully,
would,
it's only temporary.
yeah. I don't even want to ask where
That's
where
right.
you slept.
That's right.
But also, the same thing if you had I know there's some storage companies that offer apartments to people that live on campus, if you will, to maintain security. So when they registered, they would register the address of the storage company.
Which is a
which would-
non-residential address.
Correct. So the clarification there would be just to determine what we identify as a non-residential
Address.
property. Yes,
That's
sir.
right.
Thank you.
Happy to accept clarification.
Number 4.
Thank you, Mr. Chairman. Just want to also clarify when the author of the bill talked about striking section 2.
Yes.
Lines 118, 119, and 120 also discuss if the Board of Registrars denies an elector's challenge, the challenger may appeal to the State
That
Election
language
Board.
also be removed.
Thank you, Mr. Chairman.
I see no more questions.
Thank you, Mr.
Whoa,
Chairman.
whoa. I
Oh,
spoke too
one more.
quick.
You were too quick.
I can wait till we get to the amendments portion, but I don't see a problem with someone challenging the residency and all these other things we're talking about, because you're really trying to make sure people aren't voting illegally. So I don't think you're going to have many situations like you're talking about where someone's living in the back of their store, living at the funeral home. But if they do, so what? Let's challenge it, make sure that it's accurate, and if it's legit, move on. You know what I'm saying? It's not going to be abused, I don't think. If we see it's going to be abused, then we could always repeal it later.
Well, when people register to vote and they use those addresses, then the Secretary of State does send out confirmation notices.
Right.
And your precinct card. And if that is returned, then, they can be challenged. But when they have actually received those precinct cards, and if someone presents a challenge, then you have proof that the system has worked and those electors has received their precinct card and their electors. Thank you.
You're welcome.
Just to clarify, the reason why we are addressing probable cause in section 3 is to clarify for local election boards what probable cause is, because there seems to be some inconsistencies in how challenges are either sustained or denied. And we want to codify the fact that there are only a very limited number of reasons to sustain a challenge. And I would suggest that that is someone who is deceased, someone who's voted in another jurisdiction or registered to vote in another jurisdiction, who's obtained a homestead exemption in another jurisdiction. By the way, if that other jurisdiction is in Georgia, they just update their address and they vote in their homestead exemption. We're not denying them the opportunity to vote. We're asking them to update
Right.
their residency. And then finally, I do acknowledge the fact that non-residential creates some issues, but I believe, as the leader and distinguished senator from Habersham point out, these are challenges that can be reviewed and were appropriately denied and appropriately sustained.
Right. Look, I've got Senator Estevez.
Yeah, I just want to quickly note that
Get to you.
this panel of distinguished senators, all from various walks of life, the chairman just spoke about growing up in a non-residential property. My grandfather, for many years, when I was a child, was one of those storage building managers who lived on site. So just on this panel, there are two folks who would have been impacted by something like this, and I'd say the burden of having to prove your residency is a burden not only on that voter who is innocent and not doing anything other than exercising their right, but it's also a cost on counties.
I appreciate the senator's concerns. I would hasten to point out that local election boards and registrars make these decisions on a routine basis. And if we can clarify what is appropriate to sustain a challenge, we will reduce the number of challenges. I appreciate the committee's consideration.
Senator Roberts.
Well, and just as a quick follow-up, I think in Senator Estevez's grandfather's situation and in your situation, I think those would be residential addresses due to the fact that someone is living there. I think, and I mean, it has water, it has
And it's their
electricity.
permanent residence.
It
Is that not
it is a permanent residence. So I do think that it is not as big of a crevasse as we're trying to make it. Those unique, I think what we're trying to do is somebody that happens to own a convenience store in one area, but they live in another area, using the convenience store address where it's more convenient for them because they can have more influence on an election than where they should be voting. I think that's what the chairman and the authors of the bill are trying to prevent, and I think that's what we should be trying to prevent.
Thank you, committee. I think if it's a pleasure of the chairman, I will resume the chair and we'll accept input from the public.
One more.
I just want to get clarification, Mr. Chairman, from Legislative Council on line 124 on probable cause shall include but not be limited to. The use of the term "but" is to create a contrast between ideas, and that's Seminary 101. And so when you say that probable cause shall include but not be limited to, meaning that even though you specify these things, probable cause exists without those things being present. And I want to ask Legislative Council to provide clarification on that.
Be happy to provide that. Thank you, Mr. Chairman. Can I get that clarification from the rest of the
Yes.
correct. In that interpretation, yes, sir.
So that was my point. Challenge based off anything.
Stewart wishes
There's
to.
no criteria.
Huh?
You can make a challenge on anything. That's what they said. So that this criteria is for it.
I appreciate the senator's comments. I would hope that the language will help clarify what probable cause is. Yeah, absolutely.
If I may, I'd like to ask our good friend from Savannah, why would you, tell me why you would be concerned about anybody challenging someone's eligibility to vote? If I've lived in my hometown, which I have my entire life, and someone challenged my eligibility to vote in Lumpkin County, I'd be happy to provide documentation. Why would we be concerned about challenging somebody's eligibility? Explain that to me so I can understand your point of view on that, please.
Thank you, Mr. Chairman. I'll be happy to provide clarification of that, and I will use this body as an example. If by convening in the second Monday in January, someone chose to challenge my voter registration status while we're convened in the Georgia General Assembly, which we have been convened usually Monday through Friday on most weeks, if that challenge were to happen and notification be sent to me by the United States Postal Service, someone comes by my home, grabs the mail, and places it in a big stack. I don't go through that mail until after session, and so by this 45-day time limit, if we convened in January and we adjourn at the end of March, I would have missed that because my bills come electronically. Therefore, I pay them online. So when I go through the actual mail, it won't be anything of that importance unless it came via certified mail, in which case I would have to go and retrieve that from the post office. So by virtue of this legislation, if I were to be challenged, Mr. Majority Leader, then my inability to respond in the 45-day timeline would be in jeopardy. And that's just using me as an example because I do drive 4 hours from Savannah to come. And so if someone chose to challenge me, that challenge would then be sustained because I had not responded.
If I could respond.
Chair recognizes Mr. Senator Williams.
When you go to vote, you will be informed that you have been challenged, so you will not be the 45 days out. This is during an election. You show up to vote, then if you have been challenged, then your Board of Election is going to inform you, sir, you've been challenged, your residency is challenged. And then your hearing could be held right then. You produce your identification, your driver's license to show where your legal residence is. So you would not be out of that 45-day period.
And I think my point about the 45 days within the election, if we're on a May primary ballot and you're talking about 45 days, I would still be able to be challenged while I'm in Atlanta and not pay attention to the USPS mail. And so because line 123 says probable cause shall include but not be limited to, that means exactly what it says, that there is no litmus test for how you can challenge me. And so because you can challenge any voter because it says but not limited to, you can just challenge me because you want to challenge me as a voter. And I think if you're going to challenge someone's legal right to vote, that you have to have some type of substance to why you're challenging that voter.
That is the code now. That is the code now. This is not new. You can challenge anybody at any time now. If I lived in Savannah and I walked in the precinct right behind you, I see you voting, and I say, wait a minute, I want to challenge this elector. He doesn't live in Savannah. He doesn't live where he says he lives. I can challenge you at that point.
Mr. Chairman, unless I'm mistaken, on line 123, when it says probable cause shall include but not be limited to, while underlined, that means that is being added into the code.
Well, it's added into this bill, but if I'm not mistaken, and Stuart, if you can verify that, or the Secretary of State, but you can challenge anyone at any time.
Mr. Morelli.
Yes, any elector can challenge any other elector under subsection A of 21-230. If you look back on line 118, you'll see that right now the Board of Registrars already needs to determine if there's probable cause to exist to sustain a challenge. So my interpretation of the language on lines 123 through 131 are further definitions as to what the what the Board of Registrars may consider as probable cause to sustain a challenge.
Thank you. Thank you for clarification. All right. I appreciate any other questions from the committee. Senator Estes?
More of a quick comment. I want to push back on the notion that when a voter is challenged that they accept it with smiles and say, sure, I'd be happy to. I think when we're seeing tens of thousands of challenges and voters are going to the ballot box, usually on a timeline like I do. I have a set time, want to be in, want to be out, and this body has worked hard to make that process efficiently with the Secretary of State, as efficient as possible. When you're met with the fact that you've been challenged at the ballot box, that is not a opportunity to be joyful about the democratic process. That is incredibly frustrating, and I think we need to acknowledge that.
Senator Mallon. Sorry, Senator Jones.
Thank you, Mr. Chair. And just a quick comment, just because we know we may have these next year too. One of the things that would be helpful, I think, in these situations is, like, could we know how many challenges there are per year? I mean, that would be great to know by whom, because we know we have the mass challenge situation, or are these just legitimate citizens who really are concerned that there may be issues about persons' registration, and then the basis of those challenges. I mean, and not just this particular issue, but just a lot of the issues that we have to kind of stem persons having a feeling that maybe something is going on with these particular bills, because the information is there, because it all has to be kind of lodged into the database, whether it's the county register, the state election board, I've talked about that, to actually know what the information is as far as when we're trying to make these particular decisions, because we're going back and forth about the challenges. How many challenges have actually been done based on, persons changing their address but through the National Registry? How many challenges have been done because persons are dead? Those are just, to me, just legitimate things that we could know, so we could have better conversations as far as this from a trust standpoint. That's all I want to say.
I appreciate the senator's concerns, and I do think we have an excessive number of challenges. I think we need to clean up our voter rolls so that people have confidence that those who are on the voter rolls are legitimate. And then I do think we need to clarify what is a sustainable challenge. We're going to move on now for public input. I want to remind folks that we have a hard stop in about an hour. We still have input from the public, and we have more discussion among the committee. So we'll limit public input to about 30 minutes, generally 2 minutes per individual. If you'll kind of help me with that, I will grant dispensation to the Secretary of State. Ms. McGowan, are you here? Mr. Evans is here. Charlene, are you here? If you would, I'm going to ask the Secretary of State to come and address the bill so that we can, the committee can receive their input on concerns that they may have and suggestions that they may have. Ms. McGowan.
Thank you, Mr. Chairman. So I think we can be brief because you've been addressing some of our concerns in real time as the hearing has been progressing. We had some comments on Section 2, but I understand you're going to be withdrawing that section.
I would ask that you state the Secretary's position on Section 2, just for clarification.
We were going to raise some concerns about Section 2 just in terms of the State Election Board's ability to handle massive amounts of appeals of voter challenges with the resources that they have. We also feel like the superior courts, where appeals currently go to now, are the best equipped to handle appellate review of these types of decisions.
If I draw your attention to line 108, this is in current code. Either party shall have the right to appeal from the decision of the registrars to the Superior Court by filing a petition with the clerk of Superior Court within 10 days. How long does it take the Superior Court to adjudicate that appeal?
I do not have that data.
Is it a lengthy period of time?
I'm not aware of many appeals actually being filed that the Superior Courts are taking up.
And why would you anticipate that there are few appeals?
I think because a voter who is actually removed from the rolls or not allowed to vote in an election is more likely to be the party that would appeal such a decision, and I don't think that has been happening as frequently. This is pure speculation on my part. I don't actually have that information. I'd be happy to look into it. I will say, if you're concerned about timeliness, one thing the committee might want to consider is putting a deadline within 21-229E. for
All
the
right,
Superior
and-
Court to
and-
make a decision on the appeal.
So give the court 30 days, is that a reasonable
I
time?
think that's a reasonable
Okay,
amount of time.
reasonable time, 30 days for the court to make the decision on the appeal. I would also point out that there is an expense associated with appealing to the Superior Court, is that not true?
That is true.
And not every challenger or challenged individual would have the resources to pursue a Superior Court appeal, is that true?
It might be if they wanted to have counsel representing them, that would, of course, add expense to the appeal. If they did not have counsel to help assist them with the challenge before the election superintendent.
Thank you. I recognize the concern on overwhelming the state election board with challenges. I do, but I also want a challenge to receive a timely review at minimal expense to either the one who's challenged or the one who is challenging, either party. Okay. So thank you for your input on Section 2. Again, I do also appreciate the suggestion that perhaps we put a reasonable deadline on the Superior Court to provide a response to a challenge. Okay. Any other issues, any concerns as we move forward?
I will just note that if you're going to remove Section 2, then you should address the language in Section 3 on
Yes.
lines 118 to 120, which is similar
Yes,
language.
exactly. Those would also be removed. That one sentence, line 118 through 120, if the board, through election board, right, would remove that line.
Correct.
Thank you. We agree.
And then on Section 5, I believe the amendment that was offered addresses some of the concerns that we had and some of the concerns the counties have about the fact that the ballots are sealed and transmitted to the Superior Court clerk. So there was a question about how to reconcile that with the language that was in Section 5, and I do think the amendment addresses that.
Right, so Chairman Blackman was able to address those concerns with his amendment. Is that true?
Yes, for the most part, I think we have some, now reading the amendment, which we just received here, I would say that there still will be a cost associated to the counties in acquiring a high-resolution scanner. The 3 days to process the request for the digital scans is a rather aggressive turnaround time for counties to manage. We would probably suggest that be
Happy to
broadened.
consider extending that by a nominal amount. And I would say that in most cases, not necessarily in all, most cases, counties already have a scanner that would provide a higher resolution. It's just that it's a scanner primarily used for scanning mail-in absentee ballots. Is that not true? And by the way, that scanner is not certified by EAC at that level, but this is not for tabulation purposes. This is for scanning to respond to an elector's request.
Do the central scanners have higher resolution or something?
I believe that the hardware itself can do that.
So I would say that most of the time there would be no additional equipment required to provide this. It may happen on rare occasions.
I think the only thing that I'm thinking through is just the scale at which you would want to, if you wanted to get it done within 3 days.
I would accept the reality that says perhaps 3 days is too aggressive.
And
we might need
3 days is pretty aggressive. I would also say, while I recognize the goal here of trying to get higher resolution images of the ballot, just current state, and I think most everybody knows this, but the images are at up to 200 DPI, and all scanning is transparent. You have poll watchers. There was a bill last night to expand poll watcher access at polling places so the public can observe that, poll watchers can observe that, and at tabulation centers. And so I do have concerns about the timeline, and also this will increase pretty significantly after the election the amount of work that an elections office has to do if they're rescanning all their ballots. I think I might encourage, considering limiting it to hand-marked paper ballots, the absentee ballots, That way, it's not as much of a burden on the county election officials.
Is it not true that the requester is responsible for the cost of the scan?
The requester is responsible for the cost, and as it's currently written, it will take a substantial amount of time to do
And
this.
it could be a substantial burden on the person making the request.
It could be.
It could be if they requested all Fulton County ballots, for example.
Yes, sir.
Thank you. And by the way, the registrar, the local election board, has the ability to set the rate as long as it's a reasonable rate, as conforming to Chairman Blackman's amendment.
Yes, sir.
Okay. Any further concerns or comments you'd like to make?
Just in a closing comment, I want to reiterate that this year we are providing the library of ballot images
Absolutely.
that will be uploaded, and so there will be ballot images available to all voters through the Secretary of State's office and the ballot image library that we are already providing.
And we're grateful for that. We think that's a major step in the right direction. I think that Chairman Blackman's request is simply to allow those who would like a higher resolution to basically pay for a higher resolution. But I would hope that in time, the ballot images that you provide to the public, to every citizen of Georgia, would be sufficient to alleviate any concerns they may have. Let me ask one question as far as effective date in Section 6. Is there? I would suggest that Section 4 will take some adjustments in Secretary of State's procedures and documentation and training. Certainly 1/1/25 would be the earliest available date for Section 4. Do you see concerns with providing an effective date upon the governor's signature for other sections? Do you see a concern about timing of implementation if we were to adopt this legislation?
I will say that Section 5 will will require a lot of resources for the counties to implement.
So you would
for this-
rather
for
see
this-
Section 4 and 5 deferred to 1/1/25?
Yes, I think we're fine with the January 1st, 2025 effective date for all of the sections of the bill.
But would you
Are there some that
consider
we could-
an earlier implementation, primarily on the voter challenge? We're going to remove sections 1 and 3. We're going to remove Section 2, I believe. It's the will of the committee. But could we look at sections 1 and 3 as perhaps available beginning in July 1 of 24?
I think that an earlier effective date could be workable for
Thank you.
those sections.
Thank you. I appreciate your consideration. Thank you. Any questions from the committee for our friends from the Secretary of State? I want to express my gratitude to the Secretary and to the Secretary of State's office. They have worked diligently with us. Thank you. And our goal is the same. Our goal is safe, secure, accurate elections and to protect the rights of every Georgia voter. And I am grateful for their input. Thank you.
Well, thank you, and we appreciate the opportunity to work with you on these things.
Thank you.
Thank you.
All right, we're going to move quickly now through public comment. Sorry, question? No. Okay. Yeah. All right, thank you. Senator Hatchett has an appointment he's got to make with our friends in the House, the Rules Committee, and then he will return. I'm going to ask Mr. Carver, he'll come forward and provide input from the Georgia Republican Party. 2 minutes, please. I know that's aggressive.
There's been a lot to unpack here today, Mr. Chairman. Thank you very much. Brad Carver on behalf of the Georgia Republican Party. Again, thank you for your time. I want to echo the chairman's comments. We want every legal vote to count. And we applaud the continuing efforts of the General Assembly to help restore election confidence. That is important for all voters across the political aisle, and our vote, that their vote is counted in the state. And so we do not want any person to be taken off the voter rolls that is an appropriate voter. That is extremely important to us. However, you have listened to now over 5 hours of testimony on this voter roll issue. It is a significant issue. We have a number of counties in this state with more registered voters than are eligible voters. That's an issue. And so what we are trying to do is, because when those votes take place, they devalue the votes of the citizens of the state who should not have their votes devalued. We estimate again, and as I've testified before, somewhere between 800, 1,000, and 1 million votes on the voter rolls right now, which is 7 million people, are inaccurate. Now, most of these challenges are because of inaccurate entries on the voter rolls. And so, and in fact, when these things are challenged and the facts are applied to the law, over 90% of the time, that entry is cleared up. But when that entry is on the voter rolls, that is a potential for a vote to be harvested, which could jeopardize an election. And by the way, this is bipartisan. Y'all understand. There was a Republican congressman in North Carolina who was found guilty of ballot harvesting in North Carolina. It doesn't just happen on one side of the aisle. I think every single person, every senator up here, every single person in this room wants every legal vote to count. We appreciate it.
Thank you for your input. You have a question, Mr. Carver. Senator Mallon.
Thank you, Mr. Chairman. I just want to get some clarification. We talk about the challenges. Currently in statute, it talks about you got to do it in writing and write succinctly why you're making the challenge. Would you not agree that by saying it has to be based off probable cause, because probable cause by statute just means that if you have a suspicion of something, you can make a challenge. So by virtue of adding the term probable cause, you would agree with me that that is in the furtherance that you don't actually have to have any evidentiary basis to make a challenge. It's only if you think it's something going on.
Probable cause is a term we use in the criminal law, and it is there. It's certainly not beyond a reasonable doubt, not that standard. The probable cause is a much lower standard of proof, but it's there so that we don't just arrest anyone. And by the same token, that would go for this situation. We want to discourage mass challenges when not appropriate. And I think that what you have here is language that's going to help. And by the way, we have people, volunteers, all across the metro area in particular, but all across the state of Georgia that are looking at the voter rolls who know who these individuals are or the entries on the voter roll that need to be challenged. They are not attempting to remove actual voters. Now, are they 100%? No, they're not. I think the success rate is well over 90% is what we've seen. But what we have seen more recently is that challenges get made based on the facts and the law. It's very clear, and you heard this testimony, Jason Frazier in particular that I'll point you to, where the county election board votes not to remove, and so therefore, that's why we're suggesting that we need to have some consistency across the state so that state election boards do this the same way. We've asked this for this guidance from the state election board, and believe me, I'm having these conversations all the time because I think it will help guide those election boards so that we do keep down the mass challenges. I think the chairman's efforts here are for us to go forward. And I understand the concerns around appropriations for the state election board and the ability for them to stand up and do that review. But I want to encourage this panel and everyone that may be the appropriate way to do it. It is extremely.
Thank you, Mr. Carver.
Yes.
We're gonna need to move on in the essence of time. Other individuals who wish to speak to the measure are here. We have 1, 2, 3, 4, 5, 6 individuals who all oppose the bill. 1, 2, 3, 4, 5, 6 individuals that oppose the bill. I'll call you in order and ask you to make your comments. If you agree with the individual ahead of you, please just acknowledge that you oppose the bill and that you concur. So I'll start with Ms. Piercing. Did I mispronounce your name? I apologize.
No worries. It's Persons. I'm a
Persons, P-E-R. You're a proud person. Okay, very good. Thank you, Ms. Person. And I would ask you to be very brief.
Yes, sir. I will do my best. So I am Kelly Persons, and I am with the League of Women Voters of Georgia. We have local chapters all the way from Savannah to Dalton. We do a lot of voter registration work. I wanted to focus my comments particularly in Section 1, and I believe the line numbers are 20 through 22. Mr. Chairman, I appreciate your clarification that it is meant to be a mailing address, not the residency.
That's correct.
But you have residency twice in those 3 lines. So our recommendation is to simply strike out that whole section, line 20 through 22, because it's unclear and it does say residency.
Then how would you anticipate utilizing an address for a homeless person?
So my recommendation is going to be, we are already doing this. There's already a mechanism to do this, and I think it needs to be clarified. I'm actually hopeful that someone with the Secretary of State's office can come clarify this, because we have very similar questions to what you all have. We have different counties that tell us to do voter registration for these individuals in different ways, depending on what county it is. So it would be more helpful to strike this language, ask the Secretary of State what the current process is, and then do an advisory statement down to the counties of this is how you properly do it.
Fine. Thank you for your input.
Well, I was going to say, our understanding is that it's similar to y'all's. They can be registered to vote wherever they lay their head, because that is their precinct, that is their location, but they must have someone that accepts mail on their behalf. And there's lots of organizations, including shelters, churches, that do this. So I don't think the courthouse is the only option. I don't think the post office is the only option. I think there's more. And to simply, strike these lines, let's look into it. Let's get an advisory out there to the counties.
Thank you for your
That
input.
would help move it along. Thank you.
For your input. We're going to take input from our witnesses before we have any further discussion from the committee in the essence of time. ACLU, Ms. Lewiston, I'm sorry. Lessinger, saw you last night. Welcome back. I ask you to be brief, please.
Thank you. Yes, so Rachel Lastinger with the ACLU of Georgia. I'm the Associate Director of the Voter Access Project. I agree with my colleague about Section 1. I will just add to that yes, we agree that Georgia needs clear instructions on voter registration for individuals who do not have a permanent or traditional address. But we don't think that this section, the way it's written, is the answer. It's unclear how an individual would receive mail to the courthouse, and there are likely better options, and it's important that they can receive necessary notifications. There also needs to be a sunset provision on the many different registered locations unhoused people have been using at the direction of their county election offices, without a risk of those voters being successfully challenged or purged. We have a study showing that right now all 159 counties have a different way of doing this, and so there would need to be a way to implement that well.
Would this not provide consistency?
It would, but there needs to be a sunset clause, because right now it's like, if depending on when this is implemented, if you want this implemented by July, then right now somebody could be challenged just because of the transition period. So there needs to be a sunset provision in that.
If you could wrap up your communication.
Yeah, and then we just, again, the National Change of Address database is not a reliable database, and we think it should just end with line 130. It should not be, there shouldn't be a reason to pair this database with other evidence. It's just not a reliable source, and it should just be insufficient, period.
It is just one source. It is just one source, and it's insufficient in and of itself. Thank you for your input. Ms. Herring? Ms. Herring, if you would please come a little closer, Ms. Ali.
I didn't get that. Could you try again?
Siri talks too. All right, Ms. Herring?
Yeah, hi there. My name is Ann Gray Herring. I'm with Common Cause Georgia. And, I do definitely concur with the statements made before me about the residency requirements, and just want to add that requiring eligible voters to go through this burden of proving their residency is not a trivial thing. And I mostly do want to talk a little bit more about Section 3. And, I do appreciate that this bill attempts to clarify what is probable cause, because that was something that was needed in this new mass challenge landscape that we have. And I shared, Senator Burns, some of what you were talking about before about the use of the word immediately and what that means. And I understand Senator Williams' point that it's made to make an inquiry, actually immediately when that challenge is reviewed. So if that's truly what we're talking about, I think we should add a provision clarifying that all this information about probable cause that can be considered that has to be on the face of the challenge itself and not requiring election officials to do that additional research to determine whether that challenge meets these probable cause requirements. Because if they're truly trying to make that inquiry immediately, they can't do that if they're required to do all this extra work and research. And, additionally, I don't know if we've always really, considered the amount of time and resources they have to spend on these challenges and making these determinations.
We appreciate your input. By the way, everyone who has an opportunity to speak, you're also welcome to provide written input, and we appreciate that. Thank you. Miss Alley? And then Miss Napier?
Good morning, everyone. My name is Stephanie Ali. I'm the Policy Director at New Georgia Project, New Georgia Project Action Fund. I was primarily going to speak to Section 2, so thank you for consideration on striking that. I will support the striking of that section for many of the reasons that you mentioned.
Thank you.
I wanted to follow up on the conversation around mass challenges, especially on the concern of why should we not challenge a person? We have a program that follows counties in 105 boards of elections of counties across the state. We often see mass challenges brought that can be upwards of 5,000 at a time of people challenged. So far with partners, we've tracked over 100,000 challenges brought across the state since SB 202 was implemented. Multiples of these are brought over and over again. If they are rejected by the county, a person will 6 months later, a year later, put forward the same exact list. These are people who have to come and protect, come on to show themselves to protect their right to vote, to say, I am here, I am a real person. And that's taking time out of not just our counties, but our lives. As a working mom, I would be pretty upset if that happened, not just in the special situations that some of the members of the committee mentioned, but just for any given person. So again, I support shoring up this idea of probable cause and how loose it is, because it's holding up Georgians who are actually eligible to vote.
Thank you.
Thank you, sir.
Thank you for your input. Ms. Napers and then Ms. Battles.
Thank you, Chairman. My name is Krista Neighbors. I'm the State Director for All Voting is Local Action. We're a nonpartisan organization that advocates for policies that aid counties in running safe and secure elections. In Section 3, I wanted to focus on lines 123 to 26. The language says that a voter registering in a different jurisdiction would be probable cause. I wanted to suggest that you consider adding language that would make it clear that a governmental office, like a Secretary of State or county elections office, would have to confirm that information. I've attended tons of voter challenge hearings. Many times I've seen voters challenged because they appear on sites like voteref.com, which is an internet database that states up front on their site they cannot guarantee their info is correct. They claim that they have voter rolls from multiple states. The voter roll they're currently using for Georgia was last updated in November 2022, so does not include any of the updates made since then, including the massive voter list cleanup Georgia undertook last year. So I just don't think these internet aggregators are reliable sources for collecting that information. I'd make a similar suggestion about line 26, which says that a challenge should be sustained based on the challenger believing that the voter lives in a non-residential address. I've seen challengers claim that their research shows voters are living at business addresses, non-existent addresses, and then the voter appears at the challenge is like, hey, this research is flawed. I live in a house. I saw this happen to a sitting member of the Fulton County Board of Elections. Jason Frazier, who testified before this committee last month, challenged Dr. Ruth, a sitting member of the Fulton Board, and her family, saying that they lived in a business address. Dr. Ruth was like, I live in a Buckhead complex in town, or I live in a townhouse complex in Buckhead. So I urge you to add some clarifying language to this particular section. It says any challenge on this basis must include confirmation directly from a governmental office, not be based on Google Maps or these public internet databases that are often out of date and unreliable.
Thank you. Thank you for your input, Ms. Battles.
Thank you.
And then Ms. Lee.
Just stating my name for the record, Cindy Battles, People's Agenda. I understand that this has been covered, but also we need to talk a little bit more about this language with unsheltered homeless people having to register at the courthouse. I have been texting election supervisors and the members of the state election board. You actually cannot have them register at the courthouse as their residential address, and then
Their mailing address, Ms. Battles.
Okay, but it says residential on more than one line.
It points out that a residence is any person who is homeless or without a permanent address.
Right, but then they're registering the language is confusing, and I think it needs to be cleaned up because, again, some of the definitions being used as residential aren't really clear and aren't actually, like, a field is not a residential address.
That's right.
And I appreciate that you're trying to do this to make sure that folks have a residential address so that they can vote, but I think that you're underestimating the tenacity with which some of these mass challenges are going after unsheltered homeless people, and we've seen it disenfranchise people like in Forsyth County. Also, because line 126 doesn't have clarifying language about unsheltered homeless people using the courthouse, they're going to be subjected to numerous challenges, given the fact that a non-residential address is one of the reasons folks can be challenged. And I'd like to point out that this body did, well, not this committee, but this body did a study committee on unsheltered homelessness and the number of veterans who are unsheltered homeless in the state. You're not just disenfranchising unsheltered homeless people, you're disenfranchising people who have served their country and who now are. Also, I see that you're getting frustrated with me. I'm about to wrap up.
Yeah,
I will
you.
also point out that election
am.
supervisors are really frustrated with Section 5, and we're going to continue to make their jobs harder to appease conspiracy
Thank
theorists.
you for your input.
Thank you.
We appreciate you. Ms. Lee, and then Mr. Tripp, and then Mr. Favorito. Ms. Lee first.
Hi, I am in favor of the bill. On line 35, when it talks about the post
Do
office.
you oppose or support the bill?
I support the bill.
It's support and oppose. Keep going.
On line 35, on the post office boxes, I would suggest that you change it to postal addresses because there are UPS boxes, there are virtual mailboxes, and places like mailboxes, etc. And people don't live in any of those boxes. As far as the homeless go, it is important to have a residence address for every person who registers to vote, and that's where the person should be tied to, is the residence address. So the courthouse could be it currently is a residence address for the Uocava people often, and I believe the election office is the residence address for people who are on the Vote Safe program. So either of those could be used. And then they could have a separate mailing address. They can have a post office box or work out of get their mail out of another facility if they want.
Would please conclude your testimony.
Okay. Now, I am a person who does challenges, and I have appealed to the Superior Court, and I just thought this a point of information that I did that in November, the first week of November. I haven't heard anything about even getting service of process yet.
So
And
that was November, and today's March.
yes.
Thank you.
And,
Thank you for your input.
Okay, thank you.
Mr. Tripp. Brevity is a virtue, Mr. Tripp.
I'm Victor Tripp of DeKalb County. I want to thank you, Mr. Chairman, and other senators for all your hard work on this. I think you've done a great job. I think it's essentially all good stuff. I want to talk about the Blackmun Amendment. First, I want to say that with regard to all these mass challenges, it's because of mass phantoms on the voter rolls, and that's because the officials are not doing their jobs of maintaining those rolls. Now, with regard to the Blackmun Amendment, you all have done a great job of tweaking the process and improving the process, but and there's probably a lot of work still to do, but it would be a lot better, I believe, to test the process. And by that I mean an independent audit. And that's what this amendment will allow, because people will have access to the ballots. And of course, the reason for keeping the ballots, the reason for accessing them, is to do some level of audit. And these will all be independent audits.
Audits are not a part of this legislation, Mr. Tripp. The ballot access is.
Exactly.
Thank
and
you. Thank you for your input.
It will allow that.
Thank you for your
allow
input.
the
Mr.
audits.
Favorito? Be brief.
Got a handout for the.
No handouts, sir. You have 2 minutes.
Okay, I can keep that for the record.
Yes, you can. You're welcome to turn it in.
Thank you, Mr. Chairman. First of all, we support the bill, the Gone Favorito Voter GA. I just wanted to also address some of the concerns that were mentioned about the Blackman Amendment. First of all, this is a zero-cost bill to the counties, and it will improve election transparency. No counties have spoken against this amendment, and the language has actually already been approved through the House 2 years ago in Senate Bill 89. In regards to the concern about 3 days, that is current ORR law, and the ballots may be needed to resolve an election challenge, which it has to be resolved within 5 days or have to be submitted within 5 days. Another thing is ballots are really important because the Dominion ballot images are not alone enough, because I've given the committee evidence that they have been electronically altered and can be electronically altered in the future prior to certification. So that's why it's important to have ballots as public record. So we would urge the committee to basically make this everything available as of the governor's signature.
Thank you for your input, Mr. Hackney. Thank you, Mr. Hackney.
I'm Don Hackney, and I'm a retired Fulton County attorney. For 30 years, Georgia's two voter challenge laws, Section 229 and 230, were very quiet, rarely used. For instance, when someone knew and had personal knowledge that their neighbor down the street had moved to Seattle and had compelling written evidence of that fact, they could use the statutes to keep them from voting. But then in 2021, Senate Bill 2202 turned all of this on its head by adding language that allows a single person to challenge hundreds or even thousands of his or her neighbors, threatening their precious right to vote. But these challenges triggered the National Voter Registration Act, which is a federal law that significantly restricts the right of voters to vote, the right to remove voters from the voting rolls. The huge problem is that the 2021 changes to the challenge statutes didn't make any of the conforming changes that are necessary to comply with the federal act. In other words, the two challenge statutes now violate federal law in several significant ways. I ask that someone on this committee make a motion to delete sections 1 and 3. These provisions would make this situation even worse and will make the lives of election boards and their staffs even more miserable, especially since voting in the 2024 election season has already started. Let's hit the pause button on amending our voter challenge laws. Then let's let the experts craft amendments that comply with federal law. Removing the chaos and confusion surrounding this issue would be a win-win-win for the county boards, the challengers, and most importantly, Georgia's voters. Thank you very much.
Thank you for your input. Now, Mr. McKinnon. Mr. McKinnon, thank you for being here again.
Thank you. Thank you, Chair. I'm Joey McKinnon with Georgia Values Action. We work on behalf of Georgia working families across the state. We want elections to be secure and accessible for working parents. While we appreciate some efforts to do this, we oppose this bill and the cost to taxpayers and parents it creates. However, we applaud the striking of Section 2 in lines 118 through 120 and Section 3, which could lead to further delays and complications in elections. But I want to draw attention to the problem of how the voter challenge process is not in fact being used as I think we intend. Our most active county in our network is Gwinnett County, which has been impacted by mass voter challenges. In fact, Gwinnett faced upwards of 37,000 challenges last election cycle in 2022 in just one day. Further cementing of mass voter challenges casts a cloud of suspicion on honest working voters just trying to make their voice heard and potentially having a chilling effect on voting. Thank you for your consideration.
Thank you for your input. Finally, Ms. Bearden.
Good afternoon. My name is Heather Breeden. I'm with Georgia First. I will be brief with my comments. We are grateful for the opportunity to provide feedback and for the progress made on many provisions of this bill. The electoral challenge provisions may still bog down the process for elections. We have remaining concerns about election officials and the recouping of cost for filtering out frivolous challenges. As has been proposed in other legislations, counties and boards of elections should be able to recoup the cost of massive and burdensome challenges if they are found to be frivolous. We would ask for an amendment to this legislation to allow counties to recoup the cost of mass challenges. As the bill rapidly moves through the process, we look forward to continuing to work with the committee and other stakeholders.
Thank you for your input. We appreciate it. We were down a couple of members right now, or out for momentarily for other commitments. We're going to take a brief recess until we can reconstitute a quorum. Is that acceptable to the committee? So we'll recess for 5 minutes. Senators Robertson, Hatchett, and Gooch will be returning momentarily. Williams. So that puts HB 976 on the table. We will now, we'll open up for discussion and potential amendments. What's the will of the committee? Chair recognizes Senator Williams.
Thank you. In Section 5, I'd like to talk about the time to fulfill a request for the scanned ballots.
Section 5. Now this, let me back up just a second, please. We have a request from the author to substitute an amendment that I would prefer to take precedence before you adjust Section 5.
Okay.
All right. So, can I get a motion from the committee to accept Chairman Blackman's amendment, Amendment 470092?
All right. So move.
A move from Leader Gooch and a second from
Me.
Senator Williams. Now that we're working from this code section, Senator, so if you would like to make adjustments to this code section, AM 470092, it would be an amendment to the amendment from from Chairman Blackman. Yep.
You're talking about an amendment to the amendment?
Yes, I'm talking about an amendment to an amendment. Is that correct?
Did we strike Section 5?
We replace, this amendment would replace Section 5
Okay.
with Amendment 470092. So we're, right now, the amendment is to strike Section 5 and replace it with this amendment. If you wish to make an adjustment to the amendment, it would be an amendment to the amendment that was offered by Senator Gooch. Senator Gooch?
Yes, sir. I think there's concern about the amount of time to respond to these requests, and I think that's a legitimate request for us to consider changing that. I think state law currently addresses FOIAs, Freedom of Information Acts, and these records, I think the clerk of the county has maybe it's 3 days to respond to the requester, and they give them the time and the cost of what that request would be. So, for example, if I requested a block of information from my local county, the clerk would send the response within 3 days, and they would tell me that it's going to take 5 to 7 business days for that person that's most knowledgeable at the lowest cost to the taxpayer to produce those reports, and then the cost of that report would be X amount of dollars, and then as a requester I would be obligated then to either pay that fee or say no thank you, I'll try again later. So I think we ought to try to draft this amendment similar to what's already in current law, and I don't have that information in front of me. I wonder if the ACCG folks would be able to offer that to us in the room today, but I think 3 days is definitely a quick turnaround to produce that many images, and I think the cost could be significant. So I think whoever's requesting this information should be prepared to pay for it in advance. Otherwise, you could produce thousands of dollars worth of work, and then you know if the person doesn't show back up to pick it up and doesn't pay for it, then the county's out all that money. So I think that's a reasonable request we should consider.
I concur. If you look at Amendment 470092, do you have suggestions for including that language in this amendment?
I do not have that handy, but I think if we could ask for some guidance from either Ledge Council or ACCG, they may be able to give us the current law, and maybe we could mirror that as close as possible.
I think the current code 50-18-71, is that correct, Stuart? Okay, he's shaking his head. Here from Ledge Council.
Legislative Council, if you would address this concern.
So the code section referenced 15-18-71 are the operative provisions of the Open Records Act. So we could amend the language by probably striking notwithstanding any provision on lines 7, and then on lines 8 to the contrary, maybe replacing somewhere in there, so it would read, consistent with the provisions of Code Section 15-1871. Then we can probably take out the 3-day language as well. So we can probably rework the language by cross-referencing, making, instead of saying the provisions of the Open Records Act would not apply in this case, they would apply.
So we would adjust the 470092 amendment by replacing notwithstanding with consistent with any provisions. Is that correct?
Just let me read this out to myself. Superintendent, consistent with 15-1871. Yeah, so replace notwithstanding any provision of, that would be replaced by consistent with. So it would read, the superintendent consistent with Code Section 15-1871, and then to the contrary would be stricken. As would shall within 3 days of receiving such request. That would all be stricken as well. So ultimately it would read, the superintendent consistent with any provision of Code Section 15-1871.
Now that's
50-1871 shall produce digital scanned images, etc.
Does that code section include the cost estimate with the requester being responsible?
Yes, sir.
It does. Thank you. So if that's acceptable to Senator Gooch, we'd make that as a Amendment 1A. Is that correct?
Yes. Thank you very much.
Thank you.
I'll
So
second that.
have a second. So I have a Amendment 1A by Senator Gooch and a second by Senator Williams. Other areas of concern. Are there any, I'm sorry, excuse me?
Can I make a suggestion? We can start with Section 1.
Yeah,
and
that's a
go
good
through the
idea.
bill.
Thank you. And I'm going to go now first to Senator Estevez. Is that right? Or Senator Jones, which is? All right. Relating to this area, Senator?
Yes.
Okay.
Go ahead. On Section 1 on line. I'm sorry, Mr. Chair. It wasn't going to be. It would be.
It's okay. We'll go back and begin with Section 1 and consider any amendments.
Okay. This actually is in Section 3, Mr. Chair.
Okay.
It's amendment to line 126.
126.
Which line?
126. After jurisdiction, it'd be the amendment would be on an elector being registered at a non-residential address, as confirmed by a governmental office.
Or an elector being registered at a non-residential address.
As confirmed by a governmental office.
All right, is that in the form of a motion?
Yes, it is.
Second. I have a motion from Senator Estevez, excuse me, Senator Jones, and a second by Senator Estevez. That would be Amendment 2. Any discussion? We're not going to take these up until we get them all on the table. So let's defer, if we could, the discussion on the amendment. Let's go back now to Section 1. Is there any input on Section 1? Senator Estevez.
Mr. Chairman, I'd propose an amendment striking 1.1.
In its entirety?
In its entirety.
Is there a second?
Second.
Amendment from Senator Estevez, seconded by Senator Jones, to strike Section 1.1. Are there any other amendments? Senator Gooch.
I would amend line 21, strike the word courthouse and replace it with registrar's office.
Amendment number 4 by Senator Gooch. Do I have a second? Second by Senator Hatchett. to strike the courthouse and strike the word courthouse.
Yes.
And replace it with registrar's office. Is that correct?
Yes.
Thank you.
Can I follow up on that?
Certainly.
If you read that line, I don't know if it makes sense. It says, the residents of any person of this state who is homeless and without a permanent address shall be deemed the location of the registrar's office of the county in which such person resides. Is that the word resides? Is that proper, or should it be where they're registered to vote? I mean, are they, if they're...
I think that's a legitimate question. I would also maybe look at the residents of any person of this state. We might strike the word the residents
Right.
of and make it just any person of the state who is homeless and without permanent address
Right.
shall be deemed the location of the registrar's office of the county in which that person.
We need to lawyer that one up
Yeah.
a little bit. So.
I need to discuss that.
Certainly.
Some concerns on that one.
All right, Senator Williams, and then I'll go to Senator.
Like, well, you got residence and mailing address. So the residence is where they reside and where they will be given a ballot and a ballot style. And if you put all of these people in one location, it's going to inflate the actual number of people that live in that precinct. So in essence, an election, some elections are won by one vote. Someone could possibly influence an election of a precinct with commodities. I don't want to say that somebody could go with a trunk full of groceries and give them out, and okay, all of you homeless people, you're in the precinct of the courthouse. I need y'all to vote for X Sam Jones. So I have an issue with that they need to, their residence can be where they lay their head, but their mailing address could be the registrar's office.
So are you suggesting to change the term residence to mailing address? The mailing address of any person of this state?
No, the residence of any person of the state who is homeless should be where they lay their head.
I hear you, but I would suggest that if we make that, if the mailing address of any person of the state who is homeless and without permanent address shall be deemed the location of the registrar's office of the county in which state that person resides, lives, habitates.
Well, their mailing address could be the registrar's office. When they go to register to vote, they're going to the registrar's office. And then they've got to get a confirmation notice. You get a confirmation notice when you register to vote, and that has your voter registration card. And so you have to respond to that confirmation notice. So you're going to have to tell those homeless people you're going to have to come back after the state issues your confirmation notice that you have registered to vote. So there's a process that they've got to go through.
What do you recommend, Senator?
We may have to refer to the Secretary of State's office, step up and give us some input.
Mr. Chairman.
Senator Estefes.
Just really quick.
Germane to this conversation.
Yes, just to piggyback off this conversation, we are potentially changing processes across the state that have been in place for decades. As the chairman has already pointed out, people have been unhoused for a very long time, and this is not new. And what we are doing on the fly here is trying to figure out how to standardize that process across the state, which may impact not only how these processes work moving forward, but also inconvenience further those who do not have a home. And if we're trying to get them to go to the registrar's office, it could be easier going to their to their church or wherever they're currently registered. I mean, there are processes that I think we're interfering with that we're not really sure of right now.
I would suggest that a church is not a residence, nor is a homeless shelter.
Well, the
Nor is the
registrar's
registrar's
office is not a residence.
No, it's
either.
not, but it is a government office where we have the ability to verify the voter when they come in to receive a ballot. All right, I have a motion from Senator Gooch, a second by Senator Hatchett, to replace the word courthouse with registrar's office. Is there any additions to that recommendation, Senator?
No, but it's a good conversation.
How does
I'm not
Fulton
sure.
County deal with this now?
I
How
was
does
going to
your
ask,
large
what is
county?
the current precedent for a big county? Because we don't have a significant amount of homelessness.
See, I know
in
what
North Georgia.
Baldwin County did. You know, it was where they laid their head,
Yeah.
and that's where we.
But where did you mail their ballot? If they requested a mail ballot, where did you mail the ballot?
It would have gone to the post office in Baldwin County.
But as a general delivery or as a post office box?
As a general delivery.
Again, what's the difference between it going to the post office and going to the registrar's office?
Well, you said the post office is not a local building.
Well, it's not a residence, and I would suggest, as Senator Gooch pointed out, it's not a very reliable option.
But you can, when you register to vote, you register your address because that's where you're going to get that ballot style. But then you put your mailing address because you possibly get your mail not at your residence but at a post office box.
But question on that, Chairman Williams. If you go to the post office and you don't have to be homeless. If you just don't have a mailbox at that post office or in Dahlonega or in Milledgeville, wherever you live, you say, I need to pick up my mail. They're like, well, we don't know who you are. We don't have a box. We don't have an address for you. There's cases of lost mail sitting back there. You want to go through it all? You know what I'm saying? There's no process that I'm aware of for the post office to store this. And how long will they keep a piece of mail for a homeless person before they chunk it or send it back?
They actually did. These people actually went into the post office and told them, I'm homeless, but I need to receive mail and I'd like to receive it here at the post office. And the post office would hold it for them. It may not do it in every town. I can't speak for that. But I know they did in Baldwin County, in Milledgeville.
But if we pass a law that mandates these ballots get mailed to a homeless person at a post office, how do we ensure that homeless person can get access to it?
Well, I never had a homeless person request an absentee ballot. They went and voted. Most of the time, these homeless people didn't have stamps to mail the ballot back.
Mm-hmm.
So that was never an issue of an absentee ballot.
I guess that's my argument for doing it at the registrar location, because the homeless person should reasonably know where the registrar's office is. If they want to go and register to vote or change their address or get a ballot, absentee, early vote, or vote on election day, they're going to do it at the elections office.
Right.
Most likely.
Right.
Some areas may be a little different, but at least the registrar is going to be the custodian of all of those election documents.
And that can be where they get their mail, but not where their residence is.
Correct. The residency requirement will be dealt with at the registrar's office, correct?
Right.
They'll decide where you live and where your residence should be.
Right.
So.
Correct. Senator Estes?
I just wanted to add in, I think that's one of the big issues that we have here is that the language in this says residence and reside versus mail address, which is a big difference. And two, I think the perspective of the bigger counties like Fulton would be incredibly helpful here because they may have a completely different process that this may dramatically change. I don't know the answer to that, but it would be helpful to know.
Do you suggest that the residence again be changed to mailing address? on line 20? I realize you've already requested that that section be struck, but if it were not to be struck, would you prefer mailing address of any person?
I don't know what the solution is there.
Thank you. Any further comments? Right now, I have an amendment to strike the word courthouse and replace it with registration office. Is there any
Well,
additional?
Secretary of State would like to address.
Happy to. Mr. Evans, can you enlighten us?
Registrar's office.
Registrar's office.
Just one thing I'll throw out there for consideration and discussion. We do have right now built into our voter registration system the ability for registrars to designate the addresses where they know that their homeless reside. And so one of the things that could be considered is, instead of saying a specific address, the courthouse or the registrar's office, basically say that the local registrars can select what those locations are, but they have to report them to the Secretary of State by flagging them in the voter registration system. So that's one option.
Question is, would those include homeless shelters?
They could put a homeless shelter in there.
Thank you. Would they also include churches?
If there were homeless people laying their head there at night, then
my concern is that makes it a problem for mailing multiple ballots to a single address, a homeless shelter. And there's no assurance that the individual who is the registered voter actually receives that communication.
And I think that's a valid concern. But I did want to at least relay the information that we have the ability for registrars to designate those locations, and if that were to be required, that is something we could train on.
Thank you. But you also have the ability to accept that communication at the registrar's office, do you not? I mean, you could receive it and provide it to the voter if they request it. I would suggest that the registrar's office is a more appropriate location than the post office, or a third party where we have no assurances that those communications are being appropriately transferred to the voter.
I'll defer to y'all's discussion on that.
Thank you. Well, we're just moving right along. So we have we have 4 amendments, and we're not finished. Are there other discussions about sections 1? I do need a request, an amendment, a friendly amendment to strike section 2. Can I get an amendment to strike section 2?
So moved.
Senator Estes, amendment number 5.
Mr. Chairman, I can make that amendment to strike section 2 and strike lines 118.
And strike lines 118 beginning with "if the board."
Yes.
Of
120.
Board of Elections. Thank you.
Can we discuss section 2?
Certainly.
I think the cost of litigation, and I'm not down in lawyers here, but some of you guys are lawyers in the room. Y'all don't work for free, and I don't blame you. But to appeal a decision like this to a state board of elections is relatively inexpensive and easy to do. To go to court, you're going to have to hire these gentlemen out here in the room, or one of you guys, or somebody back home, and to start filing papers to get to a superior courtroom could take years. I've seen it drag on and on and on. There's all kinds of procedures and motions. If you want to expedite some of these issues and try to restore the confidence of the voters in Georgia, we need to make this as efficient and as transparent as possible. I don't care what party you claim to be in. This is about transparency and making sure that we clean up the voter rolls, and that we make sure that everybody that wants to vote in Georgia can vote, but no one should be able to vote that's not legally allowed to vote. So Am I wrong? I mean, tell me what's wrong with Section 2, Chairman. I've heard the discussion both back and forth today. I don't want to overload the State Elections Board, but that's why they're here. That's why they're created by state law. So tell me where I'm missing the boat on that.
I appreciate the leader's comments, and I philosophically agree with him. I believe that it would be better and more expeditious and less expensive if the State Election Board were the first level of appeal. I would suggest that Mr. Cohen's here with the State Election Board. I'm happy to receive any input that you would provide, but I would also acknowledge to the leader that I've gotten some pretty clear indication from both the Secretary of State's office and the Governor's office that they're not comfortable asking the State Election Board to assume these responsibilities at this time.
Mr. Chairman.
Senator Estevez.
And if I could add a little bit more context, I think there's underestimation of the fact that people do hire lawyers in front of the State Election Board, and there's a significant backlog in the Election Board already. And this would dramatically add to that potentially.
We acknowledge the concern.
That's the concern is that there's already
Can I ask a rhetorical question? Do you think there's not a backlog in the judicial system in this state?
There certainly is, but I suspect that the Superior Court would be more adept to clearing that backlog than the State Education Board or Election Board right now.
And I do recall the potential suggestion from legal counsel from the Secretary of State that we might choose to request that the Superior Court respond to these challenges in a timely manner, and that we establish perhaps what that timely manner is. I would be cautious in doing that because it's awfully concerning for us to attempt to determine when the Superior Court's action would be appropriate. Is that not true, Counselor? Yes, sir. So as much as I like the idea, I'm not really sure that that is a positive for this legislation. So if I understand Senator Estevez's amendment, his amendment would be to strike Section 2 and strike the sentence beginning on line 118, if the board, through line 20, Election Board. Is that correct, Senator? I have a motion from Senator Estevez. Do I have a second? Second from Senator Jones. What is
Mr. Chairman, one more amendment there. For Section 3. We're still going by sections, right?
Correct.
Section 3, after line 141, a new subsection K1 that states the Board of Registrars may impose a reasonable charge for costs related to this code section. The Board of Registrars shall utilize the most economical means reasonably calculated to obtain records, conduct interviews, and other tasks as may be necessary for the execution of any challenge.
Do you have that in a form where you can distribute to the community?
How does the Board of Registrars charge? They don't, I don't know of any boards that actually charge. It would be back to the clerk of the court that would be issuing, or I guess open records request. Is that what you're referring to, Senator?
I'm happy to make that the superintendent or
yeah, I'm trying to figure
whoever
out.
Can cover those costs.
That amendment again, if you would restate it for the committee. K1.
So it'd be K1 right after line 141.
Adding a section, is that right?
Yes, adding a subsection. Yes, sir.
And if you would restate that.
The Board of Registrars may impose a reasonable charge for costs related to this code section. The board shall utilize the most economical means reasonably calculated to obtain records, conduct interviews, and other tasks as may be necessary for the execution of any challenge.
If you could have that prepared and let us consider it. We're well over our time limit. It is now almost 11 o'clock. I think in the interest of cleaning up the legislation, I would entertain a motion to table HB 976 and that we reconvene Thursday morning at 8 a.m. to continue the amendment process and ultimate action on the bill. Is that appropriate?
So moved.
Second. I can do it Thursday. Sure. We're checking our calendar, folks. Wait one while we clear the calendar. Can you write your amendment up, please, Senator?
Yes.
Thank you. Just write it up for the committee. And again, this is Amendment 6 by Senator Estevez. It's a second. Is there a second?
There was a second.
Second. There was a second. Was it Senator Mallow?
It was.
Thank you. All right.
The motion to table.
I'd ask that you defer that briefly while we check with Secretary Cook's office on timing. We may still entertain that, but if you would defer it, we'll try to make sure we have all the amendments on the table before we either take action or table. Are there any other requests to amend?
Yes, Mr. Chair.
All right, one more. Senator Jones.
Also on section 3, line 125. So it says to vote in a different jurisdiction, semicolon. An elector voting or registering to vote in a different jurisdiction as confirmed by a governmental office. So just after jurisdiction, as confirmed by a governmental office.
Was
Right,
that
we had that one as number 2.
number 2?
It's two different ones.
It's two different areas.
Oh,
Okay.
Same language.
It's the same language, and the first amendment was in what section?
Page 120, line 126.
Line 126, and now this one is line 126, is that right?
125. Here's 125.
So, if the senator is amenable, could we not include that in a single amendment?
Yes.
Okay, so 125, a different jurisdiction as confirmed by a government office, is that right?
That's correct.
And then, is there a second, just right down the way in 26, it's the same thing, is that right?
Yes, sir.
So 125 and 126. 125 after the word jurisdiction,
Yes.
and 126 after the word jurisdiction, is that right?
Correct.
Good. All right, thank you. Is there any other conversation? Hearing none. We've got 2 members who are now in judiciary. And we need to make sure that Secretary Cook.
We're clear.
We're clear?
Yeah.
Okay.
Has to be prior to
Session. All right. Since we've lost 2 members and we've had a number of amendments proposed, I would ask the committee that we document the amendments, distribute them to the committee, and entertain a motion to table, reconvene at 8 a.m. on Thursday morning. Is that acceptable to committee? As far as I know, those were all the amendments. Are there any other amendments for consideration? Because I'd like to get the amendments on the table so that if we, as we return on Thursday morning, we won't have any additional amendments proposed. Certainly. Certainly.
Can we ask for some clarification, some help from others on lines 28, 29, and 30, dealing with the homeless address, whether that's a mailing address or actual residence? That seems a little messy right there.
So clarification on
Yes, sir.
lines.
And also on line 35, there was a comment by one of the persons that came before us suggesting we change post office box
Correct.
to postal box.
To
So
postal box
I think
or
that has
postal
some-
address.
Yeah, that has some merit to it as well.
I
think.
would agree. I would agree. I'd notate you that as well.
Okay.
So we're looking for clarification of lines 20 through 22, which deals with homeless. And then if it's acceptable to the leader, I have to ask the Ledge Council. Now that we don't have a quorum, can I have an amendment? I probably can. I've got to wait until we
But
reconvene.
you can instruct your legal counsel.
I can
to
certainly
draft
ask legal
those.
counsel to look at line 35.
Right.
And the term post office box and reconsider language that might be postal address. Is that correct?
I
Or
would,
what
I
would
would refer to them.
All right. And just bring clarification language on line 35. Is that okay?
Mm-hmm.
All right. A motion to table. I believe we had a motion.
So moved.
So moved. Thank you. I have a motion second. Thank you very much. Those in favor, we will reconvene Thursday morning, 8 a.m. Thank you for your time and attention to this challenge. Motion by Senator Mallett. How you doing? Oh, okay.